Thanks very much for joining us today for this property workshop. Most importantly, I hope you're all well. I hope your family, friends, and colleagues are all well, and that your companies are too. We're trying to do a fair bit at the moment to kind of give back to startups, scale-ups, SMEs, entrepreneurial businesses, many of which are in trouble, and properties probably one of the most relevant areas, and quite a specialist area. We just served our break today, which Lauren and Helen kindly led us on. Landlords vary hugely, as do their attitudes, and the terminology is quite challenging. So the idea is to work through and hopefully demystify some of it and help with Q&A in the box. And the chat function, and we'll deal with that at the end. Only to introduce you to the team, Helenlucas is a partner in our property team, and Lauren and Kath Campbell-Barnett are also extremely experienced in this specialist area of law. We've set up our dedicated website, ignition.community, which is there with lots of free resources. This will be on there as well, so that you can access it and share it if that'd be helpful. I'll let Helen talk a little bit more about what we're going to be covering in terms of leases, licenses, guarantees, landlords, and all the very relevant things that are going on. Please do interact, share your questions, and we'll try and pick those up at the end together for you. And also, if it's helpful, property@ignition.law is the email address. We'll repeat that again at the end for you if you do want anything following up with. And I hope it's a useful session for everyone.
Thanks, Alex. Hi, everyone, and thank you all for joining us today. We started to receive messages predominantly from our tenant clients almost immediately following the announcement of lockdown just over 2 weeks ago. As many of them relate to broadly similar areas, we thought it'd be useful to do a short presentation on the kinds of points we have been considering and that you may be facing at this unprecedented time. So just to say, during this seminar, we will be covering the following key areas. If, as a tenant, you can no longer afford your rent and or use your premises, what are your options? What should tenants do and avoid doing in the meantime? Does the Coronavirus Act 2020 suspension of landlords' right to forfeit help? Specific issues for licenses, common in shared space co-working type agreements. And finally, negotiating possible concessions. There will be plenty of time for questions at the end. Feel free to put them in the Q&A box and we will try and cover them all in the time. So I will hand over to Lauren to kick us off on the first area.
Thank you, Helen, and hello and welcome to everyone. Thank you so much for joining. So the first key question I'm going to be addressing is one we've had a lot from our tenant clients, and that's what can I do if I can't afford to pay my rent and I don't have access to my property? So that's the key overarching question, if you like, and I'll answer that with sort of 3 subsections, 3 other mini questions. And they will deal with termination, how you might be able to terminate your lease. The second point will be, what are your remedies against your landlord if your landlord has closed the building? And thirdly, does insurance help me out here? So kicking off with termination, we've had many inquiries from tenants saying, I really need to get out of my lease. How on earth can I terminate it? And obviously in the current climate, that's a sensible commercial option for some people. So basically, just to run through what your options are here and any potential fruitful avenues. The most substantive and fruitful avenue for you if you want to terminate is if you have a break right in your clause that in your lease that is operable. And if you do have a break right, just a big red flag, I would strongly recommend that you take legal advice on how to serve the notice under that break right and how to satisfy any conditions under the break. I'm not just saying that as a lawyer. I would sincerely offer any sort of free tips here and steers on how to operate them, but they can be particularly tricky, and they're very bespoke to each lease and each break clause. Just to put it in context, even in sort of the most calmest economic climates, there's been a plethora of case law of landlords enforcing break requirements strictly against tenants and courts upholding them very strictly as well. So more than ever is the time to get that right if you're keen to exit your lease and operate a break right, and we're here to help with that if that's helpful at all. So if you're one of the lucky ones with a break right that you can operate, obviously, and if you're minded to terminate, then obviously that is likely to be a fruitful option for you. In terms of the other potential options, they aren't unfortunately as fruitful, but I will touch on them anyway, as we've had many questions from tenants around them. So one question we've had a lot is, does force majeure apply here? Surely these circumstances, one in which would trigger force majeure, does that help me? Can I get out of my lease relying on that? As many of you might be aware, force majeure is a common provision in many commercial contracts mainly, and it enables parties to vary the level of their liability or even terminate the contract in the event of force majeure, usually an unforeseeable or extraordinary event, which indeed COVID-19 seems to be so. However, unfortunately, leases very, very rarely have a force majeure provision in them. I've never seen a lease with one. Again, the starting point is always to check the terms of your lease carefully, because it could be one with a force majeure provision, but it is very, very unlikely, unfortunately. If you have a more informal arrangement, a license of a co-working space or a shared office space type agreement with someone like WeWork and the like, they more commonly do have force majeure provisions in them. However, the ones that we've seen recently haven't been that helpful to occupants. They've been very much in favour of the landlord, the space provider, and they've not really been sort of a fruitful avenue for tenants to get out of their agreement. And Helen's going to chat later on a bit more about the shared office type agreements, as there's other things to be aware of with those, and we know that a lot of our network occupy in those types of arrangements. So similarly to force majeure, another potential option, but again it's unlikely to be operable, is the law of frustration. So it's similar to force majeure, however it's not something you would necessarily find in your lease. It's implied by law, and frustration has developed over the years in the courts. However, it does set a very high bar. Basically, it potentially enables one to terminate a contract by virtue of being frustrated. It's incapable of being performed. However, it's a very high bar. And whilst a lot of things are unknown at the moment, things are still unfolding with COVID-19. The current soundings are it's very unlikely that a temporary inability to occupy your premises would amount to a viable frustration claim. And then one other thing to touch on in terms of termination, it's not termination as such, but just sort of standing aside from your obligations within the lease, and is looking towards your assignment and subletting options within your lease. So checking your lease to see if you are permitted to assign or sublet. They are commonly permitted in most leases. However, there's often restrictions and conditions attached to them, so they ought to be considered very carefully, and we're happy to help with that. Obviously, at the moment, there's probably not much of an appetite in the market for new occupants to be taking on spaces via an assignment or subletting. but equally it's not entirely impossible. There might be some winners in this market who are well placed and for whatever reason are keen to take on property during this time. So it's worth exploring, perhaps discussing with a letting agent about the appetite in the market if you do have an assignment or subletting provision you can rely on. So that basically wraps up what your termination options are. Basically, just to summarise, the most substantive and fruitful option is likely if you have a break right in your lease. I appreciate I've said the word unfortunately quite a few times during this already. I like to find solutions and I'm always the optimist. However, obviously it's very tricky circumstances we find ourselves in here, and I just want to give a more realistic and pragmatic view of what your realistic options are. And bearing in mind the time and cost of certain avenues, it might not be a viable route. So moving on to the next subsection, you might be asking, my landlord has closed the premises. Can I withhold rent or even terminate because I can't access my premises? In summary, it's highly likely that you cannot withhold rent in these circumstances. Most commercial leases have a provision in them saying tenants cannot deduct or offset rent against any other claims they may have against the landlord. And sort of just in general terms, with this situation with COVID-19, there's no sort of government intervention which says any of the terms of your lease or any contract is otherwise varied, apart from the relief on forfeiture, which Kath will chat more about. The landlord and tenant's obligations continue under the lease, so it's also important to be aware of that. So your obligation to pay rent and any other obligations do continue under the lease. With that said, so do the landlord's obligations. So it's likely, again, it depends on the terms of your specific lease, but it's very likely your landlord is obligated not to derogate from grants and obligated to provide certain services. So with that in mind, it is possible that you may have a claim against your landlord for any losses sustained as a result of closure of the building. However, it really does depend on the unique circumstances. The government guidance that is relevant to them, to the business, to the premises, and the current soundings are that it's highly likely that the government guidance at the moment would provide a defence to any claim for losses in that situation. So hopefully that's a helpful insight regarding closure of property and what your options might be. And finally, moving on to the third subsection, does insurance cover me here? That's a question we've had quite a lot. It's worth checking the terms of your specific policy. Most tenants have business interruption cover, and most standard policies wouldn't extend to cover for COVID-19. They only cover damage to the property or the building, which COVID-19 obviously isn't. However, do check your terms. It's possible you may have some sort of extension, which is helpful here, that might cover closure of premises, that might cover notifiable diseases. So it's worth checking the terms and also having a conversation with your insurer around the issues, just to see if that would be helpful. So I think that's everything I wanted to cover. If you have any questions, do pop them in the Q&A box and we'll answer them all at the end and get through as many as possible. Thank you for listening. I hope that's been helpful, and I'll hand you over to Kath now.
Thanks, Lauren. Hello, everyone. I hope you can hear me okay. So I'm going to talk a bit about what tenants should do or avoid doing during this crisis. just wanted to quickly touch on keep open covenants. We would advise you check the terms of your lease for a keep open covenant. This is a covenant requiring tenants to occupy the premises and trade continuously throughout the term. They tend to be more in retail, restaurant or leisure leases, although it is highly unlikely given the situation that a landlord will be able to enforce the covenant or have a claim for a future breach of covenant. We would always advise that you, where you can, forewarn your landlord of any closure, or if that ship has sailed, engage with your landlord over these sorts of clauses. It's always better to have an open conversation and understand exactly where you stand. Next, I'm going to talk about vacant premises insurance requirements. Whether you as tenant or your landlord has been responsible for taking out building insurance, you do need to be aware of what the insurance requirements are. Many of you will have had to vacate your premises for an extended period of time, either because you've had to close your business temporarily or because all of your staff have had to work from home. Most insurance policies will set out specific requirements to ensure premises are secure. The risk is that if you do not comply with these, even inadvertently, you do risk voiding the insurance and being unable to claim under it for any damage at a later date. If the landlord is responsible for insurance, you could find yourself responsible for making up any shortfall to the landlord under any insurance claim if the policy is voided as a result of your action or inactions. The Association of British Insurers have been told to be flexible, but it is important to take appropriate steps to mitigate any damage. If there are specific requirements that you are unable or unlikely to comply with, for example, provision of security and inspection and maintenance obligations, we do advise you speak to your broker or insurance advisors, or that might be the landlord's broker or insurance advisor. The expectation is that the insurers will be flexible and waive inappropriate requirements. However, we strongly advise you discuss these with your insurer directly and where possible, document these waivers. It is unlikely the government are going to pick up any bills which insurance should have covered. It has advised to leave all premises secure and with appropriate levels of security surveillance. Next, I wanted to discuss a bit about business rates. As I'm sure you're aware, the Chancellor has announced a 12-month business rate holiday for all retail, hospitality, leisure and nursery businesses in England. That's 100% discount to your bill from 1st of April 2020. There's also grant funding available of up to £25,000 for all retail, hospitality and leisure businesses with property of rateable values between 15 and 51,000. This is in part recognition, I think, for the lack of insurance cover for pandemics. We advise that you look at your own local authority website to understand what release and grants are available to you. The government has also tried to protect tenants further under the Coronavirus Act 2020 by suspending a landlord's ability to forfeit a lease for non-payment of rent. This suspension lasts until the 30th of June, although it's subject to review. Whilst this does provide some comfort, and it is meant to, you should be aware that this is not a waiver to pay your rent for this period. Tenants do remain liable to pay their rent and all other monies due under their lease. So that includes service charge and insurance. Technically, and let's hope it is only technically, depending on the terms of your lease, interest will also accrue on all late payments. Landlords are still entitled to draw down on any rent deposits they're holding, and ordinarily under the terms of a rent deposit deed, tenants are required to top these up again or risk forfeiture. Landlords can still rely on guarantees provided by third parties, either as guarantors under the terms of the lease or under authorised guarantee agreements given on previous assignments. You would need to read the terms of your guarantee to understand exactly what it says, but often guarantors will be required to comply with tenant covenants under the lease or even a new lease, or to enter a new lease if the tenant goes insolvent. This suspension of a landlord's ability to forfeit also does not preclude a landlord from seeking to collect its rent or exert pressure by other lawful means. I don't want to bring all bad news, we're coming on to the good news later. Landlords will have different pressures and they will be looking to meet their own commitments. They will be considering options like CRA or Commercial Rent Arrears Recovery Scheme. This could involve instructing a bailiff who will give the tenant 7 days notice to pay its rent, or risk the bailiff turning up at the premises. One small reassurance here is that a bailiff couldn't break into unoccupied premises. There would have to be someone there, so this isn't going to happen anytime soon. Other options being considered by landlords would be to serve statutory demands, giving tenants 21 days notice to pay the rent, or face winding up petitions. However, landlords need to be very careful here, as well as it has to be in their interest to do this. There are lots of hurdles to jump and they may be no better off at recovering arrears at the end of it. But it's a reflection of a step up in rhetoric. I think here the message is really not to assume that landlords will waive the right to rent arrears. One last point on the Coronavirus Act and this suspension from forfeiture is that it doesn't apply to leases of less than 6 months or to licenses of any duration, but Helen will touch on this in a minute. I just wanted to summarise in a concise fashion as I can. Make sure you understand any covenants in your lease that you're in breach, that you could be in breach of for reasons beyond your control. Discuss these with your landlord. Next one, make sure you understand your building insurance requirements. If you don't have a copy of the small print, ask your landlord for a copy. You will be expected to comply where you can to avoid the insurance being voided. Where you can't comply, discuss these with your insurance broker. They should act reasonably and document any agreed waivers. Check your local authority website to understand what business rates and other grants are available to you. Understand that the suspension of the landlord's ability to forfeit is not a waiver of your obligation to pay rent. Landlords understand this is a really difficult time, and where possible, we'll really want to work through this with you, but it is crucial to make contact with them to discuss concessions. I'm going to hand you over to Helen now, who will hopefully touch on the much more practical good news about those concessions that are being negotiated out there at the moment. Thank you.
Thanks, Kath. Just before I go on to the concessions, I just wanted to touch briefly on the licence point that Kath talked about. A lot of the shorter term property agreements, and often those for office suites in co-working type buildings, such as those that you'll see owned by WeWork or Spaces, are expressed to be licenses, not leases. This means that assuming they really are licenses, which is quite a technical point we can happily help you on, the forfeiture concession will not apply. Great care needs to be taken with these license agreements. Although they offer many benefits in terms of the facilities provided, the agreements themselves can often be actually pretty onerous, especially because occupiers often do not take advice on entering into them, mistakenly believing them to be more flexible and less onerous than a full institutional lease. I've looked at quite a number of these over the past week alone that allow the landlord to charge the rent for the entire licence term, even if they terminate early for non-payment or breach. They tend also to have very wide clauses allowing the landlord to move the occupier into other spaces, not necessarily of equal quality or size, and to suspend all services without recourse, and often have very draconian clauses relating to non-payment or late payment of rent, which need to be considered very carefully before deciding what to do at the current time. So, moving on to negotiating other concessions. You may well have been reading the various news headlines in this area, as I have been, and seen all sorts of examples of how some of the landlords and tenants out there are dealing with the pressures of the coronavirus, and wondering if any of these could apply to you. So just a few of the sort of big headline examples. Fuller's and Shepherd Neame pub landlords have waived all rent from tenants for the upcoming quarter. Argent are waiving all their rent at King's Cross for the March quarter. Transport for London and Network Rail have agreed to charge no rent for 3 months in all their retail spaces in their stations and arches. And Land Securities have purportedly created an £80 million relief fund equating to 3 months' rent for its small and medium-sized business tenants. British Land, another huge landlord, have waived all March quarter rents for its smaller retail, food and beverage and leisure tenants, and they are apparently deferring the March quarter rents over the following 6 quarters from September 2020 for their other retail, F&B and leisure tenants. Grosvenor and Cadogan similarly waiving March quarter rents, and some of the really big tenants such as Primark and Burger King are apparently simply refusing to pay. Which would make sense because the larger landlords, some of them are reporting that only about 1/3 of their March quarter rents from retail tenants anyway have currently been paid. On the flip side to that though, other landlords are being very clear that they will start proceedings the minute the forfeiture suspension is lifted. So bear in mind, a lot of the published government reliefs at the moment are very much centred around retail, leisure and food and beverage, those being the most obviously first hit by the closures. A lot of the landlord agreed concessions, certainly those making the headlines, are also focused in these sectors. And a lot of the landlords that are seemingly giving the biggest concessions have been the larger, more generous, appearing more generous, are the larger ones, possibly with deeper pockets. Got to bear in mind that others may be under more financial pressure themselves and less able to give these concessions. There's obviously a very big difference between the ability of a large institutional landlord with hundreds and thousands of properties to agree concessions versus a small family-owned or individual landlord with just one or a handful of properties. Now, I'm assuming that a large proportion of our audience today is probably made up of smaller, medium-sized companies and startups without the negotiating power of a Burger King or a Primark, and possibly more concentrated in office sector rather than retail and leisure, although we do certainly have tenant clients in those sectors. So I'll try and keep my points applicable to everybody. Firstly, I would say it is still reasonably early on and the situation is changing daily. There's a trade-off between approaching your landlord too early, if you're not genuinely too badly affected as yet, versus waiting too long so that the landlords can see that there's light at the end of the tunnel and perhaps can get away without giving you particular concessions. Landlords currently refusing to budge may perhaps be more inclined to do so once there are sort of more headline taking insolvencies of the big tenants. And once, of course, if you get to the point where you or other tenants have got impending insolvency, they may start to appreciate more that they may need to share the pain to the extent they have the headroom to do so themselves and their own finances allow it. At present, we would advise, as Kath and Lauren have said, the best option is really via negotiation, and therefore to keep pushing your landlords to seek to agree a concession. Whatever you do, absolutely do not bury your head in the sand. Keep an open dialogue with your landlord. Landlords are not currently obliged to make concessions. However, it's clearly not in their best interest to let all of their tenants get into financial difficulty either. So there is often some room for negotiation. Landlords will look at each situation individually to consider where concessions are most needed, and assuming that they do not have the ability to grant them to everybody. They will weigh up the likelihood of the ongoing financial viability of the particular tenant versus the risk of having an empty property potentially for a prolonged period, and they will need to factor in the fact that they will most likely have to grant rent-free periods to any future incoming tenants. And of course, if they were to have to go down the route of repossession proceedings, there would be costs associated with that too. As you can imagine though, the landlords have been inundated with approaches from almost all of their tenants, so it's a good idea to be realistic about what they might be willing and able to agree. It's always best to express these conversations as being without prejudice to keep open your future options for renegotiation. As Lauren was saying, it's of course critical to check the terms of your individual lease or license and any ancillary documents because they are all different. depending on their terms and depending on the flexibility of the landlord, we have seen between us all of the following being agreed by various landlords to varying extents over the past 2 weeks. Probably the most common that most landlords are happy to agree to is to change from receiving rent or from the tenants making quarterly to monthly rent payments. Some are suggesting, instead of paying quarterly rents in advance, to change them to quarterly rent in arrears, just to give you a little bit of breathing space. We've seen rental holidays of up to 3 months covering the March quarter's rent. We've seen periods of reduced or half rents. We've seen landlords agreeing to use all or part of rent deposits in lieu of the March quarter's rent. Sometimes, in most occasions, they requiring those to be topped back up. But obviously, as tenants, you can try and agree as long a period as possible to repay that rent deposit. We've seen some tenants agreeing to extend their term in exchange for a rental holiday now, which could work if you're certain that you want to stay in the property for a long time, but obviously we wouldn't be advising that if you've got any uncertainty as to whether you want to stay. We've seen agreements to remove or push back existing tenant break rights in exchange for some rent-free now. We've seen reduced rents to reflect the fact that there are very few, if any, services being provided at the moment. And the final and most controversial one we've seen, which I wouldn't necessarily be advising, is that some of the tenants in these kind of shared working offices, and also some of the big leisure tenants, have actually been grouping together and just agreeing between them that they are not going to pay to get the landlord's attention. This, I would say, is very much a last resort, because as Kath and Lauren have already detailed, the landlords still have all of their remedies apart from the forfeiture one at the moment, and they will likely seek to use them. So I think this would really have to be a last resort. You could end up being in a worse position than you are now, with your rent still due and interest and costs on top of that. So as we have said, hopefully you'll manage to negotiate some concessions with your landlords. And if you are, it's really important that we get this documented properly. This is not a lengthy thing. It can generally just be exchange of letters. It's quite a quick thing to do, but just to make sure you don't end up in, with any dispute or further costs down the line, it's a good idea just to have a simple exchange of letters now to cover these points. Right, well, that was the main content of the actual seminar that we wanted to cover. I'm just going to have a look to see, oh yeah, we have some questions. If you do have any questions, just ping them on the Q&A and we will cover them, but I'll have a look and see what we've got already. Okay, the first one, should rent deposits be ring-fenced? And if so, how can we ensure that that is the case? I'll just start and then see if Kath and Lauren have anything they want to add. Rent deposits are all drafted and they all have different drafting in them, and they're all held in different ways, but you do often see that they have a requirement for the landlord to specifically set up a new independent standalone account to hold those specific monies. So the first thing I would say is you need to look carefully at the wording of your rent deposit and check that that is the case, because some of the bigger landlords in particular will refer to having sort of intermingled rent deposit accounts where it's all mixed in together. So the first thing to do is check the terms of the rent deposit, and obviously we can happily do that for you. I don't know if Kath or Lauren, anything different on that, or would you? I
don't know. Generally rent deposits continue to belong to the landlord, to the tenant, and are charged to the landlord. So I think they probably are ring fenced. If you're talking about a landlord being in jeopardy, I don't think they'd go join the queue as the creditors can be paid with. Lauren?
Yeah, I agree with what you've said, and I think it largely depends on the terms of the rent deposit and how that states it should be held and what should be done with it. I think that would be the starting point, just looking at the detail of the rent deposit.
Yeah, I agree. Hopefully that answers your question. If not, you know where to find us. We're happy to follow on up afterwards. Gosh, we've got a lot of questions coming through now, everyone. Hi, we want to terminate. We have a break clause with 3 months notice, but our deposit is 2 months. What is the risk of me just cancelling and not paying the 3rd month and therefore losing the 2 months deposit instead of paying the full 3 months? It would be cheaper, and I can't imagine it being seen as a breach of the terms and conditions, as there is a clause saying that if we don't pay, we forfeit our deposit, and so we are just using that mechanism. Lauren, maybe one for you?
Yeah, I'm happy to pick this up. I would be cautious about withholding any payment of rent without any agreement with the landlord, particularly as I see there's a red flag there that you have a break clause on 3 months notice, and query if that break clause is conditional upon payment of rent. So you might feel like you have a small win with the fact that the landlord can offset the rent deposit, which I agree is a pragmatic solution, but it would have to be agreed. However, in doing so, you could thwart the break effectively and find yourself tied into a longer term. But it would very much depend on the terms of your particular lease and the break clause and the wider circumstances. But yeah, we're happy to help further if you want to get in touch with us about that. But yeah, my red flag would be there if there's any, if the break clause is conditional. And as Helen sort of flagged earlier, it's a very risky approach to do anything such as withholding rent without agreement of the landlord.
Yeah. There's one here, I'm not entirely sure I follow the question. It's to do with, gosh, they're coming through so quickly. Every time I try and read one out, it disappears. There was one about if your landlord goes insolvent. I think I can't find it now.
Or management company.
Yeah, management
Yeah,
company.
have you got that one? Can you see that one?
Yeah, it's at the top. What happens if the management company who you have your lease with goes under? Do you have obligations to the landlord if that happens, despite the contract not being clear on this?
I'm not quite clear whether the management company and the landlord are the same person. I don't know if you guys are reading that the same way.
Yeah, I think we'd have to have better clarity on who the agreement is with directly. Is it with the landlord, and does the management company have obligations under the lease as a third party, or have you directly contracted with the management company in some way?
It would also depend on what type of insolvency that, you know, and what stage it is at, and things like that, or whether you're dealing with an administrator or but very, very happy to pick that one up later if you want to send us an email or give one of us a call. It might be one where we need to see the copy of the lease on that one, I think. Hi, we rent a kitchen with many kitchen units. We're seeing a sharp increase in demand, though facing cash flow difficulties due to our investment round being pushed back. We'd like to continue using the building, but we need a couple of months grace given this setup. Are we protected under the latest legislation from being evicted? Our landlord also provides us with utilities on the same invoice as rent. Are they at liberty to set these off? Maybe, I'm not sure. As to the forfeiture, it depends on the lease or license or how it's set up. If it is a lease, then you will be protected from forfeiture. But as the lady's covered, it doesn't actually mean that your rent isn't due. So you will be required to pay it before the forfeiture suspension comes to an end. Otherwise, you would be at risk of forfeiture. I'm not quite clear on the utilities point at the end there. It's some rents are inclusive of service charge, insurance, rent, things like that. Some aren't. So it depends how the lease provides for those things. I don't know if there's anyone else.
I think with the service charges and the utilities that you're talking about, I think non-payment of them constitutes the same as non-payment of rent.
Yeah.
In a technically. I think it's just a question. It sounds like you've got investment coming around the corner. Then it's a question of just having this conversation with your landlord. hopefully they'll understand and sort something out for seeing you through this.
Yeah, I would agree with that, Kath, very much so. You know, I think, as we've said, it obviously depends very much landlord to landlord, and very much on their situation as well. But they are also not going to want to see all their tenants getting into trouble. So especially if you are a tenant that so far has been a good tenant, has been paying well and all of those things, I would hope that you would get, you know, a reasonable response. Next question, if you negotiate a reduced rent, are you deferring this? I can't, they're kind of, well, it depends what you're agreeing. I would, by reduced rent, I was referring to, you know, some people have been able to agree a period of, say, half rent for the March quarter to help them through this time. If you're talking about a rent deferral, that's more the kind of situation where perhaps a landlord might say, you don't have to pay your March quarter's rent now, but we will actually reclaim that. Let's say over the next 18 months, you'll pay a little bit extra in each of your invoices. So they're kind of two different things. It might be that you agree a reduced rent, but actually you have to top that back up over the next period. It's very much a kind of commercial question as to what you're able to agree commercially with your landlord, I would say. Anyone else? No? Agreed? Okay. Okay, kind of linked to that. I agreed a 50% reduction in rent over email with the asset manager in my building. He later went back on this and only offered a deferral. Do I have any right to hold him to this? Lauren, maybe?
Yeah, that would very much depend on the terms of that initial agreement, and if indeed it did amount to a valid agreement under UK law. We'd have to analyse that for you and confirm, but it is possible to reach an agreement over email if certain components are met. So I think really we'd need to see the detail of that and whether the subsequent you know, his withdrawal, whether that sufficiently amounted to some sort of counter offer or sufficient withdrawal.
Yeah. So I'm just whizzing through the questions because we're almost out of time, and I just want to cover as many of the areas as we've got as possible. Have you seen, oh, it's disappeared. Have you seen anyone negotiate a break or termination if you don't have one by paying the next quarter rent and the landlord keeping the deposit, for example? I haven't seen anyone negotiate this as yet. I don't know, Kath or Lauren, have you seen this, anyone?
No, I haven't come across it, but certainly it's something that could be agreed if both parties are happy with that, if it makes sense in the circumstances, but I haven't personally seen it so far.
No, I think it will really...
Yeah, I mean, we didn't talk too much about surrenders, but, you know, if it's in both parties' interests to terminate the arrangement and for the landlord to move on and try reletting the premises, then, you know, the surrender option, which I think this is what that amounts to, is something that can be discussed. Landlords aren't going to agree to too many at the moment for obvious reasons.
Okay, a few here about concessions from landlords. A lot refer to hospitality. What about other high street small businesses like hairdressers, manicure, beauty salons in particular? I mean, a lot of, obviously they're kind of retail type properties, so I would hope that the landlords would treat them very similarly in so much as they're having to shut right now and physically can't have any clients through the door. I don't know about any of the other concessions. I haven't looked. Kath, did you look at the rate?
I mean, I'd always, yes, you've got to, I think, definitely go onto your local authority website and see what could or couldn't be available to you. I think that's the best advice at the moment, because it's such a everything's moving so quickly.
Exactly. Have we got time for one more? Oh, this is a tricky one. What happens if your landlord is non-responsive to a request for a rent deferral? Numerous emails and phone calls, but literally no reply. How would you proceed? That's tricky. Anyone? I mean, yeah. Lauren, Kath?
It's a difficult one, really, for not being responsive. I mean, it touches on the point that you made, that some occupants and tenants are grouping together and not paying rent to get the landlord's attention, but obviously that has its own risks with it, as you highlighted. The other thing I can think of off the top of my head is there any leverage you can get? Is there a break option, for example, in your lease? You might not be minded to operate it, but it could provide some leverage and get the landlord's attention, bring them to the table, use that as a negotiating tool. Yeah, that's all I can think of, really. It's a tricky one.
Yeah, I can see how in that situation you would be tempted to, you know, withhold some payments, kind of get their attention, because they certainly will get in touch at some point if you don't. You would just have to be very careful about what the interest provisions and things like that were in your lease, because you don't want to then, you know, by trying to save yourself money, end up with big interest costs or costs of the landlord in dealing with exercising their rights to, you know, claim the money, etc. So yeah, you'd have to look very carefully at your lease terms, I would say, on that one. But again, happy to help if we can. Sorry, I'm conscious we've gone a little bit over time, and also there are still some questions unanswered, but we are all here and happy to help. You've got our individual email addresses on your invitation, and also, as Alex said, there is a property@ignition.law email address, which comes through to all of us. So if there are any more questions, or if we didn't quite cover your point in that Q&A session, we are very, very happy to help. And I think that's all we wanted to say. Thank you very much for coming.
Thank you, everyone.
Thank you. Thank you.